All right, good morning, everyone. I'm Judge Jackie Powell. This is First Appearance Court. Today, I'll let you know if I've determined probable cause from the police reports I read this morning, and then we will talk about release conditions. Today is not your trial date. Neither is it an adversarial hearing. And so because of that, I encourage you to speak with your attorney before speaking on the record. Everything in this courtroom is being recorded and can be used against you at a later time. For those of you who are represented by the Public Defender's Office, these attorneys are available to you. And Mr. Dale Miller is in the courtroom with me this morning. Over at the main jail, Mr. Hector Romero is there. And for those of you at the other facilities, these attorneys are available to you by phone. In the courtroom, I have the attorney from the State Attorney's Office, Mr. Eric Linder. Ma'am, if you'll state your name.
Ferdani.
Okay, Ms. Ferdani. And then we also have representatives from confinement status, pretrial supervision, the clerk of courts, and all these persons are here to help with this morning's hearings, and they can provide additional information if needed. For those of you who are represented by private counsel, your attorney will come to the courtroom. If your attorney's not here and you know for a fact that you have retained an attorney for this arrest, you can let me know and we will see if we can reach out to that attorney. Please don't tell us that you have private counsel if you or your family have not retained them. Just because you spoke to them or somebody made a phone call, if they have not said that they're representing you, they're not representing you. If they've represented you in the past, it doesn't automatically mean that they're representing you here today. If they're representing you on a pending matter, it doesn't automatically mean that they're representing you on this new arrest. So please bear that in mind. Some of you this morning may be able to resolve your case at first appearance. That is only applicable to those who are facing misdemeanor charges or municipal ordinance violations. And then, even then, it's going to be dependent on what's going on with you personally. Those of you who are facing felony charges, those of you who have violation of probation warrants where the judge already signed that warrant and said it's a no bond hold, there's nothing that can be done about that here at first appearance. You must appear before your division judge to resolve those cases. Those of you who don't yet have a division judge, after today, your case will be assigned to a specific judge. Then moving forward, any pretrial motions that you may have, or if you end up going to trial, will be heard by that division judge. All right, so let's begin the morning. I don't know, Mr. Miller.
Good morning. I'm sorry to interrupt the court. I've been advised by the main jail that there are several defendants who need to come out of
That was
order.
going to be my question.
On page 7, Horatio Francis.
Who else? Just give me all of them.
Yes, ma'am. 11, I have Mr. Batista.
Okay.
Page 17, Verright, and he'll be proceeding pro se this morning.
Okay.
Page 19, Jackson,
Okay.
and page 25, Mash.
All right. And Mr. Romero, we have two persons who are on page 23 that we have a deputy who's signed in on those persons. So when you are ready with Kenneth Douglas and Terrell Jenkins, if you will let me know, and so we can address
Yes, I will,
this.
Judge.
Okay?
Yes, I will.
All right, so let's start with Mr. Francis on page 7. Mr. Francis is before the court this morning for one charge of aggravated battery causing bodily harm. It's domestic in nature. And I find probable cause. And I'll hear from the parties.
Does pretrial have any history on Mr. Francis, by any chance?
we need a photo order?
Yes, I'm gonna be requesting a photo order.
Out of the state of South Carolina, oh,
2009, domestic violence, high and aggravated adjudication. 2017.
Your Honor, based on the prior domestic violence offense and the use of weapons and injuries suffered by the victim in this case, including facial fractures and fracture of the orbital bone, state would be requesting a $10,000 bond, no victim contact.
okay.
Just being Mr. Francis, I do not believe he's gonna be able to afford a $10,000 bond. I've had an opportunity to speak to him. I have not had an opportunity to review the PC affidavit. But in speaking to Mr. Francis, he is looking forward to having his day in court. He was defending himself. I am gonna be requesting a photo order for the numerous injuries that Mr. Francis sustained as a result of this incident. Having said that, Judge, he's 40 years old. He's been living in our community for the past 2 years. Right now, he's currently in between jobs. He's looking for work. He was working previously at a local hotel as an electrician, making about $21 an hour. But right now, he's no longer employed there, and he's currently looking, as I said. I did advise him that there's going to be a no-contact order. He will adhere to it. He'll be living separate and apart from the alleged victim. He'll reach out to his friend, who I believe resides in Pompano Beach, and that's the friend that also he's going to reach out to see if she can afford to help him post a monetary bond. He believes at most, using the service of bondsman, we're going to be requesting a $3,000 bond on Mr. Francis' behalf, Judge.
All right, finding probable cause, I am going to impose a $7,500 bond, no victim contact. And the no victim contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, Mr. Francis?
Yes, Judge.
Okay. All right, Frank Batissa,
Mr. Batista, come on up. Batista. Oh, Batista. Come on up, please. He's approaching, Judge.
all right, Mr. Batissa, his case is on page 11. Mr. Batissa is before the court on a KPS. It's a misdemeanor KPS. You did not appear in court on October 2nd for your arraignment. The charge there is petty theft. All right, so I find probable cause.
Judge, speaking to Mr. Batista, he advised me, I believe the incident location was at a Publix in which merchandise was recovered, so I do not believe there's going to be any outstanding restitution issues. Having said that, he wishes to see if the state has a plea offer for him today.
The offer be adjudication time served.
Judge, he wishes to accept the state's offer, and I was just letting him know as far as potentially the priors with petty theft on the third, it can be enhanced. They can file it as a felony, even though it's a misdemeanor amount, knowing that he still wishes to accept the state's offer, Judge.
All right, so Mr. Batista, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. And do you understand everything that has been discussed with you today? Is anyone forcing you to resolve your case?
No,
Are you under the influence of drugs or alcohol?
no.
Do you need any more time to speak with your attorney?
I don't, no.
Do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Correct.
Have you ever been treated for mental or emotional illness? And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
I understand, I'm a citizen.
What plea do you wish to enter at this time, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence serves adjudication time served, okay? He gets 6 months to pay his court costs. On page 17, Traverse Verit.
Judge, he's here at Maine, he's approaching, and he declined to serve as a public defender, he said he's gonna represent himself.
All right.
How you doing?
Good morning. Good morning, sir. Do you understand that you are entitled to counsel for this hearing? Do you understand that?
I would like to take the counsel.
Okay, so the public defender's office is right there, and Mr. Romero is there. Sure. All right, Jacoby Jackson on page 19.
Mr. Jackson, come on up, please.
All right, so Mr. Jackson is before the court. Charge one is violation of felony probation. This has a no bond hold for Judge Duffy, and you are scheduled to see Judge Duffy tomorrow morning at 8:30 a.m. Charge number two is driving while license suspended. It says first offense. I find probable cause. You have a $100 bond there, right? Page 25, Joseph Mash. Is Mr. Mash? This was a medical reset from, I believe, yesterday.
It was for a couple of days medical reset, Judge, but he's here present at Maine.
All right, so Mr. Mash is before the court this morning. Charge one, resisting officer with violence. Number two, carrying a concealed firearm. Number three, possession of cannabis, 20 grams or less. Number four, DUI, alcohol or drugs. Number five, resisting officer without violence. And number six, possession of open container in a motor vehicle. I find probable cause for these charges, and I'll hear from the parties.
Your Honor, the state is requesting a $5,000 bond on the resisting without violence. With violence, Your Honor, he was in arm's reach of a gun, as well as he was violent throughout the whole encounter.
Okay. And does he have priors?
Yes, Your Honor, he has a 2003 resisting without violence, as well as a 2007 possession of cocaine, and a 2010, no, never mind, that was no cost. Those are his priors, Your Honor.
Mr. Romero?
Judge, I understand that Mr. Mash has priors, but as you heard, they're dated. Having said that, Judge, he is disputing the facts as alleged in the PC affidavit. We're gonna be requesting a photo order so we can photograph them, the injuries Mr. Mash sustained as a result of his interaction with law enforcement. Judge, right now he is working, he's a project manager at a roofing company. He's been working there for about 1 year. He's been here his whole entire life, he's 38 years old. He lives locally here in Fort Lauderdale with his mother. I believe they pay about $900 a month. Judge, one thing, I believe, he's gonna try and self-bond. Unfortunately, when he was arrested, he didn't have his, phone with him, so he has no one to contact. But he has a debit card, or, slash credit card, so he's gonna try and see if he can self-bond if the bond's not too high. But we were gonna be asking on count one, the third degree felony. Judge, we were gonna be requesting a $500 bond on Mr. Mash's behalf.
All right, based on the allegations that is present in the probable cause affidavit, I am going to impose a $3,500 bond on charge number one. Okay? All right, then that would be it for the persons that the jail is asked to call out of turn, except that Mr. Farid is on recall. Okay? On Mr. Plant, on page 2, Sharika Ricketts.
Maine, I think, or North Broward, sorry.
On North Broward, Sharika Ricketts.
Two.
On page 2.
Hello, Your Honor.
Good morning.
He's
I
having
was
breakfast.
eating.
Are you sharing breakfast with everyone else?
I'll bring you down a sandwich.
Okay. So
Where do you need 'em?
where's Miss Ricketts?
Miss Rick, I already told him Miss Ricketts was down here, but she is very inappropriate. I couldn't keep her down here.
All right, so we'll have to reset Miss Ricketts. All right.
Sorry about that, Deputy.
All right. On page 2, then Erica Hollander. All right, Miss Hollander, you are before the court for a misdemeanor KPS on a municipal ordinance violation. This KPS was issued December 12th on a loitering solicitation charge. So,
Judge, our offer is,
ma'am, what do you want to do today?
I would like to resolve it.
Mr. Plant, what is the offer?
it's adjudicate time served, Your Honor.
All right, Ms. Hollander, the city of Dania Beach is offering you time served to resolve your case. Do you wish to accept that?
Absolutely.
All right, ma'am, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Ms. Hollander, do you understand the offer that has been extended to you to resolve your case?
Yes, I do.
Is anyone forcing you to resolve your case?
No,
Are you under the influence of drugs or alcohol?
I am not.
Do you need any more time to speak with an attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, ma'am, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
I do.
What plea do you wish to enter at this time, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication time served. Good luck.
Thank you.
Good luck, ma'am.
All right, on page 9, Pablo Roca.
He's coming up, Your Honor.
All right, sir, you are before the court because this morning you have 3 misdemeanor cases on municipal ordinance violations. You did not show up for your arraignment April 5th and then August 23rd. And you have charges of carrying open container, and no lodging on city-owned property. All right, so what does Mr. Rocha wants to do today?
His offer would be adjudicate time served.
All right, sir, the city of Fort Lauderdale offers time served to resolve your case. Do you want to do that today?
Yes, ma'am.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down. Please state your name for the record, sir.
Pablo Rocha.
And Mr. Rocha, do you understand the offer that has been extended to resolve your cases today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with an attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Rocha?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication time served.
Good
All
luck,
right,
sir.
Thomas Duncan on page 10.
Duncan. That's the one who, medical reset, Your Honor.
All right, Mr. Duncan is a medical reset. Thank you, Deputy. And then David Bostic on page 11. All right, Mr. Bostic, you are before the court because you have a KPS on a misdemeanor charge. You did not show up for court on September 27th. The charge there is alcoholic beverage violation. I find probable cause. Mr. Bostic, what do you want to do today?
I'd like to resolve the case.
All right, Mr. Plant?
Yes, Your Honor.
All right.
Time served.
The offer to resolve the case is time served. Do you wish to accept that, sir?
Yes, ma'am, thank you.
All right, Mr. Bostic, please raise your right hand so we can take a plea. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. Mr. Bostic, do you understand the offer that has been extended to you today?
I do.
Is anyone forcing you to resolve your case?
No,
Are you under the influence of drugs or alcohol?
no,
Do you need any more time to speak with your attorney?
no,
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
yes,
Have you ever been treated for mental or emotional illness?
no,
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
yes,
What plea do you wish to enter at this time, sir?
no contest.
I accept your no contest plea, find that it's freely and voluntarily given. Your sentence serves adjudication, time served.
Thank you, Your Honor.
You are welcome,
Good luck,
sir.
sir. Thank you, Judge.
All right. Are you ready with Traverse Verit?
Yes, Judge, I am.
All right, so let's address that case at this time. He's on page 17.
Sorry.
Mr. Verit, you're before the court on one charge of grand theft auto, and I find probable cause for that charge. I'll hear from the parties.
Judge, unfortunately, Mr. Varit is not in a position to call anyone to help post his monetary bond. My understanding is he resides in Orlando. He's from Orlando. He's been here for about 2 days trying to visit family. He's 29 years old. He is working in Orlando as a dishwasher at a restaurant there. He rents a studio apartment. The judge right now, he's really can't contact anyone. So he's asking to be released on pretrial release on this nonviolent offense, where because he resides in Orlando, we're going to be asking him that he be able to report by phone.
Your Honor, state would oppose, he has no ties to the community. 2, I'm showing 2 arrests this year already, one in, both in January this year on failures to appear. Sorry, one in March in Osceola County, another in Osceola County in January for failing to appear in court. I'm showing another arrest in 2018 for failing to appear in court. Another arrest in 2018 for failing to appear in court. Looks like he was, in 2017, picked up on an out-of-county warrant based on a failure to appear. I mean, there's history, Your Honor, but frankly, based on just the recent failures to appear, I'd ask that the bond be kept in place.
All right, so based on the nature of the charges and what has been presented to this court this morning, I am going to leave the bond in place at $1,000. And I am also going to order that Mr. Verit not return to the Tri-Rail station at Sheridan Street. Okay? All right. Do we have, are you ready with Douglas and Jenkins on page 23?
Almost, Judge, if we could have a
All right.
couple more minutes.
Mr. Romero, up to what page do you have persons in the room?
Oh, let me enter the page. We're trying to find out right now, Judge.
All right, so let me tell you then, there is a Rolando Fernandez on page 19. If he is in the room or when he's in the room, if you'll let me know.
Mr. Fernandez, are you here? I will let you know, and they'll go and get him right now.
Okay.
19 Fernandez.
All right.
Yes, private counsel.
All right, yes. And so then let's continue with Cecilia Stamp. Ms. Stamp will be reset to the PM, is what I'm being told.
Yes, yes.
Okay. All right, Miranda Rivera.
She's approaching, Judge, you hear me?
All right, Ms. Rivera, you are before the court this morning on one charge of aggravated battery. Offender knew or should have known that the victim is pregnant. I find probable cause. Anyone wish to be heard?
Yes, Your Honor. Showing a previous arrest in 2014 for a burglary with a battery that was dropped. Based on the level of violence, Your Honor, I'd be requesting a $3,500 bond, no victim contact.
Judge, did the state say 3,500?
Yes.
That's reasonable, Judge.
All right, $3,500, no victim contact. No victim contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, Ms. Rivera?
Yes.
Okay. Next we have Odalis Fernandez Gomez.
North Broward, Judge.
All right, Ms. Fernandez Gomez is before the court on a KPS on a misdemeanor charge. You did not show up for your hearing on December 9th. The charge there is theft to deprive, and the judge issued a $500 bond on that matter. Okay, I find probable cause.
Your Honor, they send the court date to the wrong place again.
Ms.
And I
Fernandez,
didn't know
please, Ms.
when I
Fernandez.
found out because I report every
Ms.
day
Fernandez,
to my
can you
trial.
allow me to speak to the judge briefly, and if you have anything to add? Judge, I did speak to Ms. Fernandez Gomez this morning. She advises that essentially she didn't get notice. I was looking at the Register of Actions, and it appears that she has changed her address at least twice during the pendency of this case since July. It would appear, it's unclear whether she had notice to be in court on the 9th. However, she did change her address on the 11th. She's not trying to run from this case. It just appears that she's having trouble meeting the court's schedule, and that may be because she is currently undergoing chemotherapy. She does have an appointment in 2 days, and she's advising she has no one to bond. I would ask the court to consider these facts and to release her to the services, to the supervision of pretrial services, who can help make sure that she does appear before Judge Levy-Cohen, Judge Levy in the future.
Your Honor, here's the problem. Ms. Fernandez Gomez appeared before you in late November advising you about her chemotherapy, and you released her to pretrial. And then she failed to appear again. And you advised her she cannot fail to appear. You advised her, if you don't know when your court date is, contact pretrial, contact the public defender, contact the clerk.
I did.
It's the same, and I sympathize, Your Honor, but it's the same explanation again.
And Judge, it's clear from the record that she has been in touch with
I did.
at least the judicial assistant of Judge Levy. She's not, it just seems to be, everybody's having trouble getting on the same
What does
schedule.
communication say to Judge Levy? What does it say? Are you looking at something?
The KPS, Your Honor, was issued on the 9th, so it's going to take one moment. I've timed out.
Your Honor, she did the request to Judge Levy 2 days before she was arrested on the KP. She even put her on pretrial. You told her.
No,
No,
I
what I'm saying is
remember.
there wasn't a request since you placed her on pretrial, is what I'm saying.
Okay.
Judge, I'm sorry, I timed out, so I lost.
Pre-trial, can you confirm if Ms. Gomez has been reporting to pre-trial?
We have to reach out to her through time.
And Judge, the KPS was issued by the clerk, it appears.
So here's a problem.
no show at a hearing.
Right, so the problem is, I do have an independent recollection of Ms. Fernandez Gomez. It was the exact same affect and response that I had the last time, that I did clearly tell her that even if she's feeling sick on a particular day, that she has a responsibility to get somebody to call. And now we're back before the court, and it seems like she only takes action after the fact. So I don't know what's going on. So based on that, you do have court with your division judge tomorrow. What is the charge is theft to deprive. And I can't tell her what to do. So she has court tomorrow before her division judge, or post her $500 bond. Okay?
Thank you, Judge.
All right. Tiffany Sowers,
Your Honor, they called me up this morning and told me that she was already done and she was canceled. You're done.
that is true. I don't know why right, we did that yesterday. All right, Kanisha Stokes. Ms. Stokes' bond, Ms. Stokes's bond has been posted. Okay, so I find probable cause.
And Judge, whenever the court is ready, Mr. Fernandez on page 19 is here present, and also whenever the court's ready, we're ready to proceed on the two gentlemen on page 23.
All right, so let's address Mr. Douglas on page 23. He had signed in first. So Kenneth Douglas.
He's a prisoner.
If I could be heard before the court.
Sure.
Your Honor, and this applies to both Mr. Douglas and Jenkins, and I spoke to Mr. Miller about this. I know on your findings and on the booking, it shows false imprisonment. I direct the court's attention to the probable cause affidavit. As you can see, it's on the offenses charge, it says kidnapping, false imprisonment. Detective Pelusia, who authored the probable cause affidavits, is present. I can tell you as an officer of the court, her intent was that they be charged with kidnapping. If you want her to provide that information on the record, that's fine also.
No, that's fine.
We would be asking to proceed under the theory
Sure.
that these were kidnappings.
Okay. All right, so Mr. Douglas, you are before the court this morning on charge 1 is kidnapping. And let me read it as it's on the, it says kidnap, false imprisonment, adult, and number 2 is a violation of felony probation. That has a no bond hold. It says that it's an interstate violation of probation, okay? And so that has a no bond hold. I find probable cause.
Your Honor, the probable cause affidavit makes reference to video surveillance that was obtained from the McDonald's and the Shell gas station. Detective Pelusia has brought that video, copy of that video surveillance today. I already had the detective show Mr. Miller the copy she has. I'm going to be asking, if she'd be placed under oath, I'm going to be asking her if the court would allow to present the surveillance to the court.
All right, Detective, if you'll raise your right hand, do you swear or affirm to tell the truth?
I do.
And please state your name and title for the record.
Detective Morel Palushai, Violent Crimes.
All right,
Broward Sheriff's Office.
And what capacity?
I am assigned to the Violent Crimes Unit.
And how long have you been a detective?
In that specific unit for 1 year.
And in total?
I was assigned a year and a half to a property crime and about a year and a half to street crime, so in total about 4 years.
Okay. And were you assigned to investigate an alleged kidnapping that occurred December 17th on Broward Boulevard in Fort Lauderdale?
Yes, sir.
And you authored a probable cause affidavit with respect to that that offense?
Yes, sir.
And which individuals were arrested and charged with that kidnapping?
Kenneth Douglas and Tyrell Jenkins.
And do you recall in your probable cause affidavit making mention of surveillance video that was obtained from a Shell gas station and a McDonald's?
Yes, sir.
And did you have an opportunity to view the surveillance video that was obtained from those two locations?
Yes, sir.
And my understanding is you brought a copy of that surveillance to court this morning?
I did, sir.
And the video that you have with you today, is it a fair and accurate representation of the surveillance that was taken from those two locations?
Yes, sir.
Your Honor, if it please the court, I'd ask if Detective Palucci could approach and show you the surveillance.
Okay. Is it queued up? Okay. So,
So this is when he was first
okay.
taken into custody. There's an audio.
Thank you.
And, Detective Palucci, you had an opportunity to speak to the clerk at the Shell gas station?
I did.
And did he advise you if he was able to observe both Mr. Douglas, Mr. Jenkins, and the alleged victim?
Yes.
And based on his observations, was he able to advise you if he believed the victim was in fear?
Yes.
What did he advise you?
He stated that initially he did not realize that the victim was chained due to the plastic and all the obstruction on the glass. However, when he was pulled into the vehicle, he noticed that the victim was taken against his will.
Further?
Yeah.
To Your Honor, the state would be opposing to any cross-examination.
It's not an adversarial hearing, Mr.
Very well.
So, Your Honor, the state would be seeking a finding of proof evident or presumption great upon, that Mr. Douglas be held no bond at this time. You've been presented with the video surveillance that shows Mr. Douglas and Mr. Jenkins forcibly taking the victim from one location, that being the McDonald's. They then arrive at another location, and somewhere in between, they actually put chains on this man. He goes into the Shell gas station. You can see at one point, I believe it was Mr. Douglas forcibly grabs him by the chain, and by the chains leads him out of the Shell gas station. A witness that observed this advised to believe he was in fear. This was done against his will, Your Honor. It was severe enough that a bystander felt the need to stop a law enforcement officer and bring this to their attention, Your Honor. There's also testimony provided by Mr. Jenkins that I believe corroborates and supports the allegations that this was, in fact, a kidnapping, that he was held against, one moment, Your Honor, that he was confined and abducted, and there was an intent to either inflict bodily harm or to terrorize the victim, and I think it's self-explanatory from the video surveillance that he was being terrorized.
Judge, I've reviewed the probable cause affidavit, and there is at least some indication that the two parties involved believe that this person who they allegedly abducted had committed some sort of property crime against a member of their family, and they were simply trying to attempt to recover that property. And so the intent is not to terrorize or to inflict bodily harm, but rather to recover stolen property. And that's all over this probable cause affidavit, and that's what I wanted to ask the detective about. And so I would ask the court to take that into consideration. I know this is kind of an argument without any hope of a positive conclusion for my client because they have the violation of probation, but I don't believe the court should be able to find proof evident presumption great just because of the mitigating factors.
And Your Honor, I would note,
So a person chained several times with chains and chains around his hand and being dragged and pushed into a car by someone is not grounds for finding for kidnapping? Is that what you're saying?
Judge, I'm
Because
saying that
they were
the
trying to
intent
retrieve
here
something
was not to terrorize or to inflict bodily
and
harm,
punching the
which is what
person in the
state
face and
indicated
dragging them
was
on the
right to do.
ground is not grounds for bodily harm?
and Your Honor, I would argue the intent was to obtain.
Oh,
under-
there's
by
no intent,
terrorizing.
it happened.
What I'm saying, but by terrorizing.
All right, I find
I'm
probable
sorry, Judge,
cause.
I just wanted to
Yes.
finish the argument. What I'm saying is the intent was to recover the property. These gentlemen, based on what I read in this probable cause affidavit, resorted to self-help rather than involve law enforcement. And that's where this case is. It's not a strictly going out and abducting people off the street in order to inflict harm or terrorize. There is something else going on here, and that's what I'm asking the court to consider when deciding whether proof is evident or presumption is great.
Right. I believe that argument is going to be made in some motion hearing at some other time. For this morning's purposes, I find probable cause. I am going to make a further preliminary finding of proof evident presumption great. This is without prejudice for Mr. Douglas to have a Arthur hearing before his division judge. Okay? And so until such time, he'll be held no bond. And then, and also, Mr. Douglas, if Mr. Douglas will come back. There is a no victim contact order in place. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, I don't even know how to get in contact with him.
All right, okay. All right, Terrell Jenkins on page 23 as well.
Your present, Judge.
Your Honor, the same would be making the same request as far as the charge the court makes the finding on, and the same, would be relying on the same argument and the same video surveillance evidence.
And Judge, I would renew my objection based on the same issues.
All right, so noted. So Mr. Jenkins is before the court on one charge of kidnapping, false imprisonment. Number 2, he's on a violation of felony probation with a no bond hold. Number 3 is possession of drug paraphernalia. Number 4, resisting officer without violence. And number 5 is another violation of felony probation with a no bond hold. I find probable cause. He is a co-defendant of Mr. Douglas. And so I make a further preliminary finding of proof evident presumption great, and he will be held no bond on this charge. He does have a hearing before his division judge tomorrow on the violation of probation. No victim contact, and Mr. Jenkins, that means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Amen.
Okay. All right, thank you, folks.
Your Honor, we have a Spanish interpreter.
Yes, well, let me address, if Mr. Fernandez is in the room, let's address Mr. Fernandez.
He's the present judge of private counsel there.
On page 19,
Morning, Your Honor. Jonathan Friedman on
Good morning, Mr.
Fernandez's
Friedman.
behalf.
Have, all right, so Mr. Fernandez, is before the court on 2 charges of lewd and lascivious molestation, the victim less than 12 years of age. And I find probable cause for these charges.
Your Honor, the state would be seeking a finding of proof evident or presumption grade on both counts, and that Mr. Fernandez be held no bond. I can tell you, and I spoke about this with Mr. Friedman, I see that he's scheduled for an arraignment before Judge Allspector tomorrow morning. A little confused about that because I checked Odyssey and the case is in fact assigned to Judge Siegel. I don't know, maybe he's out and she's covering arraignments. I don't know, but that'll get figured out.
Judge, either way, I'm going to ask the court to consider a bond this morning. Let me just give you some background on Mr. Fernandez.
Well, and before Mr. Freeman, if I could just put on the record what I'm asking the court to
Okay.
consider. I provided the court and Mr. Freeman with a copy of the information, 2 supplemental reports, and a transcribed statement from the victim's victim's sister, who was a witness to some of the incidents.
Yep, oh, no problem. Judge, this case began back in July of this year. There was a restraining order filed against Mr. Fernandez, myself, Mr. Mendito, who's also present. We've been representing him aggressively in that case. That case is set for a final hearing before Judge Stephanie Moons in March of next year. However, I want to point out to the court that Mr. Fernandez has known about these allegations. He's known about the police investigation since July. He's been appearing at all the hearings regarding the civil restraining order, and in fact, he was ready to self-surrender, and he had a court hearing set for tomorrow, which he was going to be present at.
That's a hearing before Judge Moon?
No,
Or
it's
something else?
Apparently, it's the arraignment on the criminal case.
Oh,
There's arraignment on this case, Your Honor.
oh, okay.
I would also point out, Judge, that during the pendency of the civil restraining order case, Mr. Fernandez submitted himself to a polygraph examination, and he passed, non-deceptive. That polygraph was done by an individual with 30 years of experience who does work with the state attorney's office and works with several of the police agencies here in South Florida, and was a former police officer himself. He's passed the polygraph exam, and that was at the request of the alleged victim's mother in this case. Additionally, my client's gainfully employed. He's a honorably discharged veteran of the U.S. Air Force, where he was a sergeant. He's been in the Civil Air Control. He's worked for the Department of Corrections in the past. He's got an impeccable employment record. He has there's no issue with his flight risk whatsoever. He was here in the courthouse yesterday for a hearing before Judge Moons. We're asking the court to set a bond. This is a case he's been aware of, as I said. The report, if you looked at the police report, it is a delayed report, number one. We've taken the deposition of the mother in this case, in the civil case, and there's certainly reason to suggest or doubt the allegations made. In fact, the mother, who was the complainant in this case, suggested that her father, Mr. Fernandez, submit to a polygraph. And when it was asked, why would you want him to take a polygraph, it was suggested in the deposition under oath that, well, if he passed it, I would maybe reconsider whether I believe my daughter's allegations. So this is what we're dealing with, Judge. I think a reasonable bond, he's got hearing tomorrow anyway, is appropriate in these circumstances. He passed the polygraph at the request of the victim.
Are there any
And I
temporary?
provided that polygraph examination, I believe, was provided to the state attorney's office, to the case filer in
Are
this
there
case.
any temporary orders in place
There-
in regards to the injunction?
Yes, there's a temporary restraining order in place. He's had no contact whatsoever with his daughter, with the grandchild, with any of his grandchildren for that matter. So he doesn't live with them. He's gainfully employed. I don't see any reason why the court cannot set a very reasonable bond in this case, obviously with other conditions if the court deems it appropriate, electronic monitoring or any of those things, but I don't even think that's necessary.
Based on the nature of these allegations, I think it really comes down to the court's determination whether proof evident or presumption grade exists or not. If the court does not find it exists, then obviously he's entitled to a bond. If the court finds that it does exist, I think based on the nature of this offense, it would be appropriate to allow this matter to go to a full Arthur hearing. I understand the information that Mr. Freeman's providing, but I think that especially considering we have a victim that these allegations occurred sometime between the ages of 6 and 8. It is an aggravating, the allegations are of an aggravating nature, and I think a court should have an opportunity at least to hear from both sides. As far as the polygraph test, Your Honor, well, I mean, the obvious response is there's a reason why those are not admissible in trial.
If the other party stipulates they are,
The other party being the state,
if the other party stipulates, yes.
I don't know that the state stipulated to it, so.
Well,
you-
the victim, I'd suggest,
And
ask
Mr.
for it.
Freeman, I mean, you know, I'm trying to avoid a back and
The
forth.
statement, we don't, the statement is from the victim's sister
There-
that has been provided to me.
Yes, Your
Is
Honor,
there
there
a
was-
statement from the alleged victim?
I could check to see, Your Honor. I know I can tell you a forensic examination was done. Your Honor, it is, what I've been advised is we are not allowed to turn that over. It is
Okay.
but I can check to see if, and it does make reference to the forensic examination taken of the alleged victim.
No, I saw that.
The forensic examination is merely an interview. There was
I
no
know.
physical evidence, no DNA, there was absolutely nothing.
I know exactly what it is. All right, so I've reviewed everything. There is, well, it's a sister who's an independent witness, whose statement was taken by law enforcement. And so based on the allegations, I do make a preliminary finding of proof evident presumption great. However, there is also other pending matters as reported by counsel. And there's already a no contact order and a civil matter that's pending. And so based on that, I will exercise my discretion to set a bond this morning.
Your Honor, what I would be requesting is a $75,000 bond in each count. You have found proof evident or presumption great on 2 punishable by life offenses against a child well under the age of 12. I would also be requesting pretrial release with a GPS monitor, no victim contact, and no contact with minors.
Judge, I think the bond request by the state is really tantamount to no bond. I understand the monitor, if the court wants to keep tabs on them, but to impose a $150,000 bond, I know Mr. Fernandez works, but he doesn't have those means, Judge, to afford that type of bond. And that would be tantamount to no bond. I think pretrial release, the electronic monitor, whatever other conditions can be imposed, I think are sufficient for Mr. Fernandez to be released, Judge.
At this point, at this juncture, I find that a reasonable bond. I'm going to set $50,000 on each count and order no victim contact and no contact with minors.
Is that without prejudice to readdress potentially with the
So
division judge?
everything at first appearance is without prejudice.
Thank you, Judge. See you tomorrow. Rolando, see you tomorrow. See you tomorrow.
All right, who needed the Spanish interpreter?
Judge, there's 2 gentlemen that require the assistance of Spanish interpreter. The first person is on page 10 of the docket. His name is Mr. Caballero. And the second gentleman is on page 13. His name is Mr. Nieves. Señor Caballero. Come on up, sir.
I have Mr. Nieves. All right, Wilson Caballero, sorry. Please raise your right hand. Do you swear or affirm to interpret from Spanish to English and English to Spanish?
I do. Good morning, Your Honor. Solange Sands, S-A-E-N-S.
All right, Ms. Saenz, thank you.
You're welcome, Your Honor.
Wilson Caballero is before the court this morning on one charge of trespassing on occupied structure or conveyance.
Señor Wilson Caballero ha comparecido hoy. Es un cargo de entrada ilegal en un lugar o automóvil.
And I find probable cause.
Decidimos que existe motivo fundado.
All right.
Judge, at this time, nothing to add. I'm going to be contacting Mr. Caballero's friend to post a monetary bond.
De parte de la defensa no vamos a hablar, a hacer argumento, pero vamos a dejarle saber a la señoría que nos vamos a comunicar con una amistad del señor Caballero para pedir ayuda en pagar la fianza.
All right. Mr. Caballero has a $25 bond.
La fianza es $25.
All right.
Señor Caballero.
Jose Nieves Mojica
Mr. Nieves?
on page
He's approaching, Judge.
13. All right, Mr. Mojica is before the court on charge 1 is leaving the scene of a crash involving damage to property.
Señor Mujica ha comparecido hoy por una acusación de fugarse de la escena de un accidente donde ocurrieron daños de propiedad.
Number 2 says leaving the scene of a vessel accident.
Número 2 dice que se fugó de la escena de un accidente involucrando un bote.
I was looking, is that charge, that's not applicable.
Your Honor,
Parece que no, parece que es una equivocación.
yeah, I would direct the court's attention to the PC affidavit.
Yes.
It's just supposed to be another, I'm sorry. You could-
De parte del Estado le pide a la señoría que mire al documento de motivo fundado. Parece que tiene que ver con otro asunto.
I see,
It
leaving
was
the
just another
scene.
form of charging, and it's in the alternative.
Sería una forma alternativa de presentar los cargos.
I do know the standard bond for leaving the scene of an accident is not $1,000, though.
Sabemos que la fianza regular, cuando a una persona se le acusa de fugarse de la escena de un accidente, no es $1,000.
All right, so it's leaving the scene of a crash involving damage, and then leaving a scene of an accident with property damage, and then number 3 is possession of an open container, I'm sorry, in a motor vehicle.
Entonces, el primer cargo es fugarse de escena de un choque y causar daños de propiedad. Segundo cargo, fugarse de escena de un choque. Tercer cargo, tener un envase de bebidas alcohólicas abierto.
So I find probable cause.
La señoría decide que existe motivo fundado.
All right, and I'll hear from the parties. State?
Vamos a escuchar de las partes ahora.
Nothing from the state at this time, Your Honor.
Del Estado, nada en este momento.
Judge, I was originally going to be requesting to have Mr. Nieves released on pretrial release. He informed me that he didn't have anyone's phone number to contact.
De parte de la defensa, anteriormente íbamos a pedir que lo dejaran en libertad bajo supervisión del programa de supervisión previo a juicio, porque nos dejó saber que no tenía el teléfono y no podía comunicarse con nadie.
Well, let me ask,
But
there are
it came to a
two,
big surprise
oh,
that Mr. Nieves saw his employer here, so that's the person he would like to call, but since he's here, he's going to be relying on him to post a monetary bond, so nothing to add at this time.
Ahora justo se ha sorprendido y ve que está aquí su jefe y con esa persona es la que se hubiera comunicado para pedir ayuda para pagar la fianza. Así que de parte de la defensa no vamos a añadir algo en este momento.
all right, good morning, folks. Is there something that you wanted to say?
Mr. Nieves does work for us. He's a very reliable person. He got scared last night in that situation, and that is what happened.
To be posting his bond?
Yes, ma'am. Yes, Your Honor.
Entonces, de parte de las personas presentes aquí, le están dejando saber a la señoría que el señor Nieves sí trabaja para la compañía de ellos, que es un empleado muy responsable. Parece que se asustó anoche, eso es lo que ha ocurrido, y le han dicho a la señoría que van a pagar la fianza.
Mr. Linder, did you indicate there's no priors?
No priors.
All right.
De parte del Estado no encuentran antecedentes penales.
I'll leave the total bond at $1,000.
Muy bien, la fianza queda entonces en $1,000.
Thank you, Your Honor.
All right, you're
Gracias,
welcome.
señoría. Gracias.
All right, is there someone else who needed the Spanish interpreter?
Español, solamente habla español. No one else here at Maine, Judge.
All right, Ms. Haynes, thank you very much.
You're welcome, Your Honor. Have a great day.
All right. Dinah Gabriel,
Judge, I've been informed bonded. What case was that for?
Gabriel bonded, I find probable cause. Aaliyah Miles,
North.
all right, Ms. Miles is before the court on one charge of grand theft auto, and I find probable cause. I'll hear from the parties.
You're not supposed to speak.
No, ma'am, I'm waiting for the state to speak, and then your attorney will speak, and
Can I speak? When I get a chance?
Ms. Miles, I'm gonna
Yes.
ask you not to speak at this time. Everything you would say would be recorded. Anything you say that could be used against you would definitely be used against you later on. Okay?
Patrice, do you have any notes? I'm asking pretrial to look, because I don't have anything in my system, Your Honor. I'm showing 1 month of residence, and the address location is for Broward Outreach, so.
warrant out of where? Okay. Caution what? Okay. All right. Mr. Miller?
The only thing, Judge, is just unclear how the defendant here ended up with the keys to the vehicle. This actually reads more like a street rental situation than a theft. However, that being said, my client has advised me she lives in North Carolina. She was down here visiting. She's asked me to reach out to a member of her family. I left a message with the stepmother to get back to me. Would ask the court to keep the bond as currently set or to consider release to pretrial services.
Did you say this appears to be a rental situation?
Street.
Yes, I didn't steal
Ma'am?
it, ma'am. Oh, sorry. I apologize.
Street rental, Judge.
What?
You never heard the street rental? It's
Oh,
when you rent
street rental.
Yes.
Okay.
Yeah, I didn't steal it.
Don't explain nothing to me.
Yes,
You got a
sir.
public defender.
Yes, sir. Sorry, I've never been in a situation like this before.
Well, the allegation says, I made contact with the owner of the vehicle, Katie Ann Williams. Williams advised that she arrived at her residence from dropping off her children to school and observed the arrestee listed above wandering around the neighborhood. The arrestee walked up to Williams and asked to take her somewhere in Hollywood. Williams advised to the arrestee that she's not able to take her, which then the arrestee asked Williams to use her phone to make a call. The arrestee stated to Williams that her phone was completely low on battery and she was unable to contact anyone to pick her up from the location. Williams invited the arrestee inside her residence to charge her phone. While Williams was getting dressed, the arrestee took, I guess, away her vehicle key unlawfully without her knowledge and drove away. Williams then called the police.
That's not,
All right,
Please.
so,
I can't stress enough how unhelpful it is to your case that you not speak on camera, being recorded for use later on. So just let's let the judge do her job. She's gonna set your bond, and then we'll go from there, okay?
yes, sir. I won't say anything else. I'm sorry. I've never been in a situation like this before, but I won't say anything else.
all right, yes, pretrial?
They were arrested in January of this year for larceny by an employee as well as embezzlement. She was adjudicated on last month.
Where did that occur?
These are of North
Out of North Carolina, okay.
And then she was arrested in October of this year for assault.
And that's also out of North Carolina?
North Carolina, yes, Your Honor.
November, when you say it?
That was, October of this year.
October of this year.
No, October 13th, sorry. I hear her saying she's not familiar.
All right, so it doesn't add up that you've never been in this situation before. And based on the allegations and what I've heard this morning, I am going to increase your bond to $5,000. No victim contact.
What? I'm confused.
Sasha Johnson.
Judge, I've told
Your
her it's a
Honor, that's
medical
North Broward,
reset.
she's a medical reset.
Medical reset on Ms. Johnson. Tawana Hudson.
Judge, I've been informed she bonded.
Ms. Hudson bonded. I find probable cause. Luna Hernandez.
Paul Ryan, Your Honor, I was told not to bring her up today, since she was processed already.
Probable cause, yes, right. I don't know what happened. We did this yesterday. Okay.
Yes, ma'am.
All right, Andre Andrews.
He's approaching Judge May.
Here, I don't know if you, sorry, I took that off. But we don't need it. All right, Mr. Andrews is before the court on an out-of-state felony hold. Is it out of state or out of county? Is it Orange County in Florida, or anybody listening on Mr. Andrews? Is it, it's out of what state? Okay, so, Mr. Andrews has an out-of-state hold, it's a no bond hold, and he will have to appear before an extradition judge. All right, Christopher Gaston.
North Broward Judge.
Mr. Gaston is before the court on a charge of aggravated battery. Offender knew or should have known that the victim is pregnant. And I find probable cause. Anyone wish to be heard?
One moment, Judge. Your Honor, I'm going to be requesting a $7,500 bond, no victim contact. Mr. Gaston was arrested for resisting without violence and battery last year. The battery was against the same alleged victim as this case. That was dropped. He pled out the resisting without violence. Excuse me. 2012, uttering a forged instrument and grand theft. He was sentenced to 37 months state prison as a habitual offender. Grand theft auto 2012, sentenced to state prison as a habitual offender. Fleeing and eluding with drug possession charges 2010, 5 years state prison. Aggravated fleeing and eluding with a grand theft auto in 2010. He received the same sentence to run concurrent. Grand theft auto, grand theft 07, 17 and a half months. Grand theft auto 05. A couple more grand theft autos in 05, Your Honor. Nothing further.
Your Honor, Mr. Gaston is a 32-year resident of South Florida. I'm sorry, he's been at his current address for the past 7 years. He's unemployed. He does receive SSI. If he is released, he will reside with his mother during the pendency of this case, and that is separate and apart from the alleged victim. He believes that the alleged victim is not interested in pursuing charges. I think the fact that she dropped the charges in the previous case would support that. At this time, he is attending the MAP program at Hollywood Regional. Hollywood Memorial.
What is that?
Sorry.
What is
where
MAP
he is
program?
receiving social services, medication management, and counseling.
That's a MAP program?
called MAP, M-A-P. And I'm reporting what my client advised me. I'm
No,
not
I
familiar with the
just
program.
wanted to know what it was, so.
I think I would liken it to a life skills type program.
Oh, okay.
He can't afford to post the bond if the court would consider pretrial release with a monitor to ensure no contact with the victim while this is pending. I think that might be appropriate. Again, our purpose here is to get him back to court and to protect the alleged victim in the case.
So I am going to impose a $5,000 bond with a level 2 pretrial supervision and no victim contact. And that means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir? All right. All right, Luis Colon.
Mr. Colon is approaching, Judge. It's your name.
All right, so Mr. Colon is before the court for one charge of touch or strike battery, dating violence. Number 2 is a felony battery. And this is from a not in custody capias on an incident that occurred October 22nd of this year. And then this most recent incident of December 17th. Okay, so I find probable cause for these charges.
State is going to be requesting a $5,000 bond on count 1, a $10,000 bond on count 2, pretrial release of the GPS monitor. I'm concerned, and no victim contact. I'm concerned that both of these incidents involve the same victim. Mr. Colon was arrested earlier this year, or actually end of last year, for domestic violence battery by strangulation, felony battery due to priors and aggravated assault. That was against a different alleged victim. Charges were dropped late January of this year. 2012, he was convicted of 2 counts of aggravated assault with a deadly weapon, false imprisonment, and battery. He was sentenced to 14 months state prison as a habitual offender. 2001, he was convicted of strong arm robbery, sentenced to 12 years state prison as a habitual offender. 2001, carrying concealed weapon by a felon, 12 years state prison as a habitual offender. In 96, he was convicted of aggravated battery against a pregnant victim, sentenced to a year and a day state prison. 1993, he was convicted of aggravated battery, great bodily harm, and sentenced to a year and a day in state prison. Nothing further, Judge.
Unfortunately, I do understand Mr. Colon has a history. However, as you heard, it's been a couple years since he's had any sort of convictions or state went forward on any charges. Having said that, Judge, there's no way he's going to be able to afford $15,000. Right now, he's unemployed. He's currently looking for work. He's 46 years old, basically been here in Florida his whole entire life. He will find a separate place to live, separate and apart from the alleged victim. He's going to be reaching out to a friend to help him out, but his friend is on disability, so his friend's financial resources are quite limited. I'm going to be asking on the count 1, the misdemeanor offense, if the court would consider a $1,000 bond, and on count 2, I'm going to be requesting a $2,000 bond on Mr. Colon's behalf, Judge.
All right, so based on the allegations that are before me, now we have 2 incidents of battery with the same victim that now he's being faced with. And with the history that I've heard, I am going to impose a $2,500 bond on charge 1, $7,500 bond on 2, no victim contact, and no victim contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, Mr. Colon?
Yes, ma'am.
All right. All right, Leroy Fillmore.
Mr. Fillmore, come on up, please. He's approaching, Judge.
All right, Mr. Fillmore is before the court on one charge of domestic battery by strangulation, and I find probable cause.
Your Honor, the state would be seeking a $15,000 bond pretrial release of the GPS monitor and no victim contact. First, just so the court's aware, our office had contact this morning with the alleged victim. She advised our victim advocate she suffered injuries to her neck. She does not want contact, and she is in fear of Mr. Fillmore. In 2009, Mr. Fillmore was convicted of robbery with a firearm or deadly weapon, possession of a firearm by a convicted felon, resisting with violence, and burglary of a conveyance. He was sentenced to 10 years in state prison as a habitual offender and released from state prison September 26th of this year. 04, possession of cocaine, 5-year state prison, possession of cocaine 03, delivery of cocaine 02, possession of cocaine 02. It goes on from there, but obviously the 09 prior is the most recent and relevant to this charge.
Judge, he's 38. He's been here his whole life. He is working. He just got a good job. He's been there for about 2 months. He's with an asphalt company, and he makes anywhere about $500 per week. He'll be living separate and apart from the alleged victim. He has family that live here in Broward County, specifically his cousin, who he's going to be reaching out to with help as far as accommodations to stay during the pendency of this case, and also to help posting the monetary bond. Now, his cousin works at a local hotel at the front desk. He's thinking the most his cousin will be able to afford using the service of bondsman. We're going to be requesting $3,500 bond on Mr. Fillmore's behalf, Judge.
All right, I'm going to impose a $10,000 bond, no victim contact, no phone calls, no text messages, no social media, no third-party contact. Do you understand that, Mr. Fillmore?
Yes,
Okay. Eric Fullmore?
Fullmore, come on up, please.
All right, Mr. Fullmore is before the court on charge 1 is driving while license suspended. Numbers 2 and 3 are felony violation of probation. On number 2, there's a no bond hold for Judge Alspector. And number 3, you've been ROR'd on that count. I find probable cause.
I'm sorry, may I make an argument as to count 1, please?
Sure.
I wrote probable cause affidavit. The arresting officer indicated that, quote, the driver didn't have a Florida ID on his persons, end quote. He's charged with driving with the license suspended. I think the more appropriate charge would be no valid driver's license. And so that's my argument. There's not, what I'm saying is there's no indication that his license was suspended in this piece of it.
Is the court, I don't know if the clerk has a driving record for Mr. Fulmore? Have 1 moment. Your Honor. It's not going to be correct.
All right, so based on what I have, I don't have any tickets, that he was given any ticket or,
Your Honor, I do have, and I can provide to the court, showing that he is, his driving privileges are suspended if I can provide the court with a copy of his driving record from DHSMV.
okay. He does. Just for the record, he does, the officer does put in his report in the description that there's a moving traffic violation and that it's a driving while license suspended second offense. It's on the report. All right, so finding probable cause, he does have $100 bond, and he has court tomorrow before his division judge. Okay? Stephen Fisher? Thanks.
Mr. Fisher is approaching judge here at Maine. Come on up, Mr. Fisher.
All right, Mr. Fisher, you're before the court because it's an unserved summons that was issued November 5 for a trespassing charge. So there's a capias that's been issued with a $100 bond. What does Mr. Fisher want to do today?
Judge, Mr. Fisher would like to resolve this matter. He wants to know if the state has a plea offer for him today.
Okay.
Yeah, I don't think that'll be a problem. Offer would be an adjudication, time served, no return to the public at 600 North University Drive in Pembroke Pines.
He wishes to accept the state's offer, Judge.
All right, Mr. Fisher, do you understand the offer that has been extended to you to resolve this case?
Yes, ma'am, I do.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. And Mr. Fisher, do you have any other questions for either myself or your attorney?
No, ma'am, I do not.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, I do.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
Yes, I do.
What plea do you wish to enter, Mr. Fisher? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication, time served. Good luck. Peter Littlepage.
Mr. Littlepage is approaching. Come on up, Mr. Littlepage.
All right, Mr. Littlepage has a misdemeanor capias for not showing up at your arraignment on July 19th. The charge there is operating without a valid driver's license. I find probable cause.
Judge, my understanding, Mr. Littlepage advised me he self-surrendered in order to clear this matter up. So at this time, he wanted to see if the state had a plea offer for him.
Okay. The offer's adjudication time served.
Judge, he wishes to accept the state's offer.
All right, Mr. Littlepage, please raise your right hand, sir. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And do you understand the offer that has been extended to you today, sir? Is anyone forcing you to resolve your case?
Absolutely not.
Are you under the influence of drugs or alcohol? Do you need any more time to speak with your attorney? You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
I do.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you're not a U.S. citizen, that by taking a plea today will subject you to deportation or immigration changes?
I do.
What plea do you wish to enter, Mr. Littlepage?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication time served. Tariq Young.
He's approaching, Judge.
All right, Mr. Young, you are before the court this morning on a trespassing charge. It is a second-degree misdemeanor. I find probable cause.
Judge, Mr. Young wants me to ask the state if they have a plea offer for him.
Offered be a withhold court cost, no return.
Okay.
Judge, he wishes to accept the state's offer.
All right, Mr. Young, please raise your right hand. Do you swear or affirm to tell the truth? What was that?
He affirms.
Oh, okay. You can put your hand down. Do you understand the offer that has been extended to resolve your case?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Young? I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, withhold adjudication, court costs, and no return to that location. Do you understand that?
Yes, ma'am.
All right, sir, good luck. Michelle Rogier?
Judge, I believe confinement status has information for us.
Okay. Reset to the PM? Okay,
Honor, may I interrupt?
sure.
I just received this call from Conti. The last person on the docket, Brian Key,
Uh-huh.
he is in regular court this morning. I was wondering if we could address that so we can clear Conti.
He's gotta go to
Oh,
court?
he's already in courtroom 7780 according to
Oh,
that.
so you're saying he's not available for this hearing?
Correct. I just
sorry.
wanted to clear Conti so they could get about their business.
Derek Key? Brian Key?
Brian Key?
Yeah.
He's in court? All right. He's on the last page, Brian Key, yeah.
He's actually the last defendant.
All right,
Listen, he's probably being arraigned on this case.
okay. All right, so Cogan Clark,
Thank you, Judge.
you're welcome.
He's here present, Judge.
And Mr. Clark is before the court on a KPS. It's a misdemeanor KPS for a petty theft charge. This is, KPS was issued back in March of this year. I find probable cause.
Judge, I believe this is out of Publix in which there is no restitution issues, so he's asking if the state has a plea offer for him.
looking that up right now.
Okay.
Your Honor, the offer would be a withhold and court cost.
Judge, he wishes to accept the state's offer.
All right, Mr. Clark, please raise your right hand so we can take a plea. Do you swear or affirm to tell the truth?
Yeah, I do.
All right, sir, you can put your hand down. And do you understand the offer that has been extended to you to resolve your case today?
I do.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
I do.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
I do.
What plea do you wish to enter at this time, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence serves withhold adjudication court costs, no return to that location. Donald Sargent,
Mr. Sergeant, come on up, please. Please approach the judge.
and Mr. Sargent is before the court also on a capias. This capias was issued December 4th. You did not show for your arraignment on a trespassing charge. I find probable cause.
Judge, in speaking with Mr. Sergeant, he wishes to resolve this matter today.
Offer, documented offer from the state is a withholding court cost.
All right.
He wishes to accept the state's offer, Judge.
All right, Mr. Sargent, please raise your right hand. Do you swear or affirm to tell the truth? Okay, sir, you can put your hand down. And do you understand the offer that has been extended to resolve the case today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No, it's fine.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness? And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter at this time, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence serves withhold adjudication court costs. Good luck. Reed Roberts.
Mr. Roberts, come on up, please. He's approaching Judge Chairman.
All right, Mr. Roberts, you are before the court for a charge of touch or strike battery, and I find probable cause.
Judge, I'm going to be asking if the court would consider an ROR or releasing Mr. Roberts on pre-trial release. Now, he's 18 years old. He's been here his whole life. He's currently a student. He goes to Hallandale High School. He's a senior. He has a 2.7 GPA. He will be, from what he advised me, will be graduating this June. He's already thought of his future. He's not going to go to college. He's going to go to a trade school. Specifically, he wants to go to Sheridan Tech. My understanding, Judge, he lives with his mother. She is a single mother, basically raising Mr. Robert and his other sibling. My understanding is they live at West Park. Judge, if the state can confirm, basically he has a clean record. That's why we were going to be asking ROR. If the court doesn't feel comfortable with the straight ROR, then we would be asking for a pretrial release on Mr. Roberts' behalf.
Your Honor, I see no history, so I wasn't going to be, I'm fine with non-monetary release. I would just ask that there be an order of no direct or indirect contact with the alleged victim.
All right, Mr. Roberts, I am going to release you to pretrial supervision. It's standard pretrial. Your attorney will give you the information for the pretrial office. You,
The alleged victim and the defendant both attend the same school, so I'm thinking the 500-foot rule might not be appropriate here.
oh, that's
That's-
not,
And
not
that's why I
gonna be.
wasn't asking for the 500
No,
feet.
we're
and
not
asked
gonna
specifically
do that,
there be
'cause
no
they-
director.
All right, so pretrial supervision. Mr. Roberts, you need to show up at the pretrial office tomorrow. If you don't go, a warrant will be issued for your arrest. Do you understand that?
Yeah.
All right. And then I am ordering that you have no direct contact with the Mitchell, the alleged victim in this case, right? And that means that no contact. So if you see her coming, you need to go the other way because the onus is on you to not have any contact with her. Do you understand that?
Yes.
All right.
They are permitted to attend the same.
Yes,
Okay,
yes.
I'll make note.
All right. Taekwon Jackson.
Sure. Jackson, come on up, please.
All right, so Mr. Jackson is before the court because you have you have two cases. One, is it two? This is one case.
It's just this one case, Your Honor. It looks like,
Yeah, they put it in,
it looks like his prison sentence expired Monday.
2 days ago.
okay. All right, so you have a KPS from March 18th. The charges are resisting without violence and trespassing. So I find probable cause.
Judge, he wishes to resolve these matters. He wanted to see what the state had a plea offer for him.
Okay. Time served?
The offer's time served.
Okay. All right, Mr. Jackson,
He wishes to accept it.
please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. Do you understand the offer to resolve your case today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
Yes, ma'am.
And you gotta
Is
listen.
anyone
You gotta
No,
listen.
No, ma'am. No, ma'am. No, ma'am.
All right. That's right. That's why you have to listen. So is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you need any more time to speak with your attorney?
No, ma'am.
And do you understand, sir, that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And do you understand that if you are not a U.S. citizen, that by taking a plea today, it will subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Jackson?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given. Your sentence, sir, is adjudication, time served.
Good luck.
Kimon Miller.
Come on up, sir.
All right, Mr. Miller is before the court also on a misdemeanor KPS that was issued August 20th. The charge there is petty theft. I find probable cause.
Judge, nothing to add. I'm going to be contacting Mr. Miller's mother to post his monetary bond.
All right, he does have a $500 bond and/or a status hearing tomorrow at 8:30. Gablin Filsami.
That's North Broward, Your Honor. He's a medical reset.
All right, Mr. Filsame is a medical reset. Thank you. Trey Hamilton.
Mr. Hamilton, come on up, please. He's approaching, Judge.
And Judge, we would just be arguing that it's inappropriate to count the bullets. He can't really be charged with that, with each round as a bullet. And I would ask that he be ROR'd on count, at the very least, ROR'd on counts 2 through 22.
The state agrees with Mr. Miller with regards to bonds on counts 3 through the remainder. I think the court can find probable cause, and I think the court can set bonds on 2 counts, 1 for the firearm, the other for the ammunition. But we do agree, we're not going to be seeking a bond for each individual round of ammunition.
All right, so it is presented, Mr. Hamilton, that with 22 counts of possession of weapon or ammo by a convicted felon, 1 is a gun and the remaining are the bullets that were found. So I find probable cause, and let's talk about setting the bonds.
State is requesting, Your Honor, a $5,000 bond for the count 1 of the possession of the weapon and also a $5,000 bond for count 2 of the ammunition. The defendant does have priors. He was just recently released from prison on July 23rd, 2019 from jail for resisting without violence. And he also does have pending charges that he was arrested for on November 15, 2019 for resisting without violence, 2 counts, and an unlawful use of name and false identity. As well as he also has a 2017 attempted burglary in an unoccupied conveyance. He was adjudicated and was in prison for 270 days in jail, as well as a 2017 burglary conveyance unoccupied. He also was convicted for 270 days in jail. And those are his priors, Your Honor.
Right, you said that he was released this year?
Yes, Your Honor. He, on the resisting with violence, attempted burglary charges, he was sentenced to 270 days, and also the 2 burglaries and the resisting with violence, threat to specified individuals. He was sentenced to 270 days on May 16th. He was released July 23rd.
Okay, and then he has a pending charge, you said?
He was then arrested November 15th for 2 counts of resisting without violence, 1 count of unlawful use of false name ID. He's out on bond on that matter.
And has that information been filed?
It has been filed.
And how much bond did he post?
Looks like it was a $100 bond. There was just a bond on the unlawful use of false name ID count.
No, I'm looking at the report again. All right. So,
Chuck?
yes,
Mr. Hamilton is not gonna be able to afford the $10,000. What I was gonna be asking the court to consider is a $2,000 bond on count 1, a $1,000 bond on count 2. Now, my understanding is he lives with his mother. My understanding, his mother is gonna be the one that he's gonna be reaching out to, in combination with his girlfriend to help post his monetary bond. He's 23 years old, been here over 10 years living in our community. From what he advised me, he's been working with the same landscaping company for about 2 years, in which he makes about $250 a week. And that is why we're gonna be requesting a total of $3,000 bond on Mr. Hamilton's behalf, Judge.
all right, Mr. Hamilton, is out on bond on a very recent case just about a month ago. He was released in July from serving a sentence on another matter. Based on these allegations today, I am going to impose a $5,000 bond on charges 1 and 2. Will be ROR'd on the remaining charges. No possession of any weapons or firearms. Right, Nicholas Hinton.
Judge, medical reset, Mr. Hinton.
All right. Medical reset on Mr. Hinton. And then we have Tremaine Russell.
Can we put him on recall? I need an opportunity to speak, Mr. Russell.
Okay. Donald Smith.
Mr. Smith is approaching, Judge, and he's gonna be representing himself.
Okay.
She might do the report.
All right, Mr. Smith. Mr. Smith, you're before the court this morning. Are you representing yourself, sir? Is that correct?
Yes.
You don't want the services of the public defender's office, is that correct?
Yes.
All right. You are before the court today. Charge 1 is battery on an officer or firefighter. Number 2 is the same charge. Number 3 is disorderly intoxication. Number 4 is resisting officer with violence. I find probable cause for the charges, sir. And we need to.
I was intoxicated. I work security at the
All right, Mr. Smith, here's what I'm gonna tell you. I don't know if you were in the room when I said it, but everything in this courtroom is being. My screen just went out. Everything in this courtroom is being recorded and can be used against you at a later time. That's all I can say to you at this time, all right? All right. Do you wish to tell me anything in regards to setting your bond?
Yes, I don't remember. I was intoxicated. And I don't remember fighting.
Okay.
No.
Are you working?
Yes, I am.
Do you live alone or you live with your family?
I stay with a friend.
Okay. How much rent do you pay?
$500.
And how much money do you make every week?
I make $10 an hour, so like $400 minus taxes.
Okay. All right, Steve?
So you want to be on the one, correct?
Your Honor, the state is requesting for counts 1 and 2 a $2,000 bond and count 4 a $1,000 bond.
Okay. So, Mr. Smith, you heard, did he have priors?
No priors, Your Honor.
Okay. All right, so Mr. Smith, you heard the state is asking for, it's a total of $5,025 in bond. Can you afford that?
No.
All right, so what I'm gonna do, sir, is I'll impose $1,000 bond on 1 and 2. And $1,000 bond on 4. So you have a total of $3,025 in bond, okay?
Thank you.
All right, Selwyn Soto.
He's a person, Judge.
Have an argument, yeah.
Okay. Okay, go ahead, Mr. I'm sorry? Oh,
Uh, Your Honor, I
I
spoke
thought,
with Mr.
I
Miller.
thought
I'm
I
not-
heard that he wanted to say something.
Well, and I think it was anticipation of what the state might be moving for, but I'm not seeking proof evident or presumption. granted,
Oh,
Your Honor,
okay. All right.
At this time.
All right.
Just noting for the record, I don't feel in good faith I can make an argument that something just described as an unknown black object can rise to the level of a weapon. That being, I would ask the court to find probable cause for burglary of an occupied dwelling.
Okay. All right, so Mr. Soto, you are before the court for, I'm making a probable cause finding for burglary of an occupied dwelling. All right, and so I find probable cause for that, and then I'll hear from the parties.
Concerns, Your Honor, because Mr. Soto just appeared before Your Honor. I'm just trying to find when that was. I believe it's either November 21st or November 22nd of this year for aggravated battery with a deadly weapon. He got into a fight with the alleged victim and, according to the report, stabbed him with a knife. Your Honor set a $3,500 bond in order of no victim contact. Now we are here less than 1 month later where he's allegedly breaking into a woman's home while she is present there, confronted her, and the allegation that he lunged at her. And according to the victim, she was able to identify him because he has burglarized her home previously. I am going to be requesting a $25,000 bond, pretrial release of the GPS monitor, no victim contact, no return.
Judge, I understand this, the allegations are serious. I understand that he is out on a case in which he posted, or his family posted, a monetary bond. But I would be asking the court to consider combination of a monetary bond and supervision for Mr. Soto. He's 19 years old, been in here his whole life. He works in construction. He gets paid about $100 a day when there's work. He lives with his mother in a mobile home in Pompano Beach. Her financial resources are quite limited. She cleans houses for a living. But I was going to be requesting the court consider a $5,000 bond on count one. Considering the allegations, I know that's lower than was typically set on a burglary of a dwelling, and that is why I'm also going to be asking for the court to, besides a monetary bond, to place him on level 2 pretrial for the case that he's out on and the one that's currently before you as well.
So the case that he's out on bond on, how much bond did he post?
$3,500.
And then what was the charge again?
Aggravated battery.
How long ago was that? You said
The
November?
arrest was November 21st. And I don't believe it was a delayed arrest either, Your Honor.
All right. Just taking into consideration the case that is before us today, and knowing that the alleged victim said that that Mr. Soto is the one who's previously burglarized our home, I believe that there is cause for concern for the community, and I am going to impose a $25,000 bond, level 2 pretrial supervision. No victim contact. No return to that location. No weapons or any firearms. Ana Moore.
Judge, I've been informed, he bonded.
I find probable cause. Glenn Baker.
He's approaching, Judge.
So Mr. Baker is before the court for littering over 500 pounds. I find probable cause. It is a third-degree felony, and I find probable cause.
Judge, Mr. Baker advised me he's not gonna be able to afford to post a monetary bond. We're gonna be asking for pretrial release. My understanding, Judge, and speaking, Mr. Baker, he's 61 years old, he's been living here for 55 years. He lives with his mother, who's 85 years old, in an apartment which they rent out in Fort Lauderdale. My understanding is Mr. Baker gets disability, he has health problems, Judge, he has prior contact with the system. I believe the most recent, though, is, I believe it's 2006, possession of cocaine. Considering this is nonviolent, Judge, we're gonna be asking the court to consider releasing them under supervision pre-trial.
The state is okay with pretrial release, Your Honor.
All right, I'll grant the ROR to pretrial supervision. Mr. Baker, your attorney just handed you the information for the pretrial
Yes, ma'am.
office. You need to report there by tomorrow morning. Failure to report, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, ma'am.
All right.
Okay, thank you.
Tamsin Morenland.
He's approaching, Judge.
All right, Mr. Morenland is before the court. Charge 1 is grand theft auto. Number 2 is petty theft. Number 3, operating without a valid driver's license. Number 4 is a traffic infraction not for magistrate. Numbers 5 and 6 are a violation of felony probation. Those have no bond holds for Judge Siegel, and you are scheduled for court for a status hearing on those matters tomorrow at 8:30 a.m. So I find probable cause. You have a $1,000 bond on 1. And then, as I said before, you'll see Judge Siegel on the other matters. Ed Saul.
He's approaching, Judge.
Mr. Saul is before the court. Charge 1 is resisting officer without violence. Number 2 is leaving the scene of a crash involving damage to property. And number 3 is robbery with a firearm. I find probable cause.
Your Honor, the state is requesting no bond, proof evident presumption grade on the robbery and a firearm.
Judge, I don't have a PC on them. Do I? May I have a moment?
Sure.
Judge, we would argue against finding a proof evident presumption grade in this case. It appears that while there may have been a firearm involved, that someone else may have pointed the firearm at the alleged victim, that the firearm was pulled out after the robbery took place. And so there are mitigating factors that need to be considered. And as the court is aware, the highest standard proof evident presumption grade, based on the sparsity of that probable cause affidavit, I don't think the court should find proof evident presumption grade at this time.
Just note, for clarification, the report does allege, and the victim does allege, that it was Mr. Saul that was in possession of the firearm first. And secondly, the allegation that the taking occurred first, the statute specifically contemplates that, and that it states for an armed robbery that the defendant be armed in the course of the robbery, and the statute defines in the course as being not only at the time of the taking, but thereafter in the immediacy of the taking as well. But also, I would just note, while it might not have been brandished during the taking, clearly it would appear that he was armed at the time of the taking.
Right. Based on the allegations that I have before me, I'm not going to make a finding of proof evident presumption grade this morning. So let's talk about setting bond.
Your Honor, the state is requesting a $25,000 bond as well as no contact with the victim, no weapons or ammunition, and GPS monitoring. He does have priors, Your Honor. He has a 2015 possession of PVP, 2015 also another possession of PVP, and a 2014 loitering and prowling.
Judge, as you heard, he does have prior contact with criminal justice system, but nothing recent and more importantly, nothing similar to these allegations. Having said that, Judge, his family is not going to be able to afford $25,000. Now, we are in agreement, it's reasonable as far as the conditions, having him no sort of contact with the alleged victim and having him placed under supervision. But I'm going to be asking the court to consider a $5,000 bond on count 3. Mr. Saul right now is unemployed. He's currently looking for employment. He lives with his mother in Coral Springs. My understanding is his mother is employed. She's a caretaker, and that's who he's going to be reaching out to post his monetary bond. He believes using the services of bondsman that she can afford what I have asked the court to consider a $5,000 bond on count 3, Judge.
All right. So based on the allegations, I even though this court did not make a proof evident presumption grade finding, this is a charge for an armed robbery. There's a co-defendant. There is allegation that it was Mr. Saul who handed the gun to the other person, and he was identified by the alleged victim. My screen went out again. Okay. And so based on that, I am going to impose a $25,000 bond. No victim contact and no return to that location. No victim contact does mean no phone calls, no text message, no social media, no third-party contact. Do you understand that, Mr. Saul?
Yes.
All right, and also no return to that location. All right, Jarvis Crawford.
He's approaching, Judge.
Mr. Crawford, you are before the court, sir, because there's a charge of grand theft, and also there are 2 violation of felony probations. Those have no bond holds for Judge Merrigan. You'll see Judge Merrigan tomorrow at 8:30 a.m. I find probable cause, and you have a $1,000 bond on charge number 1. Kylie Murray,
Mr. Murray is approaching, Judge. He's here at me.
I have a brief argument, Judge.
all right?
So, Judge, it would appear that Mr. Murray has been charged with voyeurism, video voyeurism, because he was alleged to have been taking videos of people whose cars were parked in a public parking lot. So it's not like he's in a store taking videos surreptitiously. He's not peeping into people's windows on private property. According to this PC, he's in public parking lots, going up to cars where people are engaged in activities they probably shouldn't be engaged in public parking lots, and taking videos in public. I don't know if that's voyeurism, Judge. I don't think it
What does the
rises to that
statute say?
standard.
What is the definition of voyeurism?
I would like an opportunity to review the statute, but just the mere fact that this is all taking place in public
Well, we're
would
not gonna
seem
go
to
by that.
negate.
Let's go by what the statute says.
Yes, ma'am. Can we have a moment?
Yes.
Judge, we'll go right under Section 2A of the statute, at a place and time where the person has a reasonable expectation of privacy.
Gotta
And
hear the
again-
whole thing.
Sorry?
We've gotta hear the whole thing, not just that one part.
Okay, Judge.
What does the statute say?
Okay, so count 2.
He's charged on the
810
statute 810-14-1.
810.141.
Yes.
Okay, it's not actually that, sorry. Okay, so under Section 1A, located in a dwelling, structure, or conveyance in such location provides a reasonable expectation of privacy. Section 1B, secretly observes another person, intimate areas in which the person has a reasonable expectation of privacy. And so, Judge, my argument would be that in count 2, there is no reasonable expectation of privacy in a public parking lot.
Let's go further than that, than the actual details in this case. These individuals were in their car in a secluded area of the parking lot. Is it reasonable in that moment for them to expect that to be a private situation? I would also note, what Mr. Miller is not mentioning is the allegations that Mr. Murray was acting in a stealthy manner to clearly hide his appearance to them, meaning that he knew that they weren't expecting anyone to be there, or certainly video recording them. He knew that they expected privacy, or he would have just walked right up to the car and just been standing there video recorded. Why is he hiding his presence from them?
Judge, it doesn't really matter why he's hiding his presence from them. The fact is, they don't have a reasonable expectation of privacy. If a police officer had walked up to them while they were, sorry.
Stop. 810.1.
Yes, ma'am.
Such location provides a reasonable expectation of privacy.
And Judge, in the Walmart, in the middle of the day, there should be no
Not in the
reasonable
Walmart,
expectation of
in the
privacy.
person's car, parked off to the side where it is away from public. That specifically says that he had to go through the bushes and hide to put his phone up to take.
In a public parking lot, in the
All right.
middle of the day,
That will
no
be-
reasonable expectation of privacy.
That'll be for another day, Mr. Miller.
Judge, we're going
For probable
they-
cause,
I'm sorry, Judge.
I
They-
find probable cause.
Okay, and with objection, Judge.
Okay. All right, so let's talk about,
We'd ask that
Mark.
be released to pretrial based on the insufficiency of evidence here.
all right.
And this-
Judge,
You're-
that's one thing we were gonna ask the court to consider pretrial. However, if the court's not comfortable with pretrial, and speaking of Mr. Murray, he lives with his mother. His mother is required on Social Security on a fixed income. He believes at most, maybe she can scrape together $100 using the services of bondman. So in total, we'd be requesting a total of $1,000 bond if the court's not comfortable with standard pretrial release. Now, and speaking of Mr. Murray, he's 45 years old. He's been living in our community since 2005. At this time, he's not working. I believe last time he worked was about 5 years ago. My understanding is the last time he had any sort of contact with, I believe, with the criminal justice system was about 10 years ago, and he believes it was dropped. He is looking forward to contesting these allegations. He is looking forward to having his day in court and being provided with the discovery to reaffirm his position that this was at a Walmart in a public parking lot. But Judge, he's not gonna be able to afford any sort of high monetary bond. That's why we're first requesting pretrial release from Mr. Murray's behalf.
Your Honor, the state is worried that he's targeting schools and minors, and the state is requesting a $7,500 bond on counts 3 and 4, as well as he does have one prior in 2009 for resisting without violence. The state is also requesting no victim contact, no contact with minors, no possession of recording devices as well, and no return to the incident location for both locations.
Judge, one thing, minors, according to my paperwork, it's 19 years old or older. I don't see anywhere as far as minors, but I haven't had an opportunity to review the PC affidavit, so I don't know if the alleged victims are minors and this is a typo.
No,
And Judge, let's not forget that this whole thing went down under the surveillance of the police. The police were watching him do this the whole time.
regardless, Your Honor, it is clearly alleged in the report that Mr. Murray went to the parking lot of the Pembroke Pines Charter High School and Middle School. He parked his vehicle for approximately 3 to 4 minutes in several different parking spaces. He was observed, one moment. During this time, he was observed watching students walking to and from the school through the parking lot. And I think the court has to take into consideration what he's accused of doing immediately prior to that.
Watching is not videotaping, Judge. I think the state is overreaching here. This is a silly case. I'm asking the court to just pretrial release, no special conditions.
All right. I disagree with you that it's a silly case. Someone making an effort to go videotape people having sex, whether or not it's in a car or whatever, I don't know how that's a silly case. I totally disagree.
Judge, Again, in public, you do not have an expectation.
I got
of
you,
privacy.
Mr. Miller. So you can make that argument at another time. For probable cause, I did make a finding for probable cause. Charges 3 and 4. And to answer Mr. Romero's question, the second vehicle that it's alleged that Mr. Murray it's alleged that Mr. Murray was videotaping. It was determined there was a 16-year-old and a 17-year-old in the car. And so no contact with any minors, no return to that location. That possession of any device with internet access.
Why the internet, Judge? The internet's not even implicated in this case.
All right. Edward Banks,
Judge, what was the monetary amount of pretrial?
5,000 on 3 and 4. Okay. Mr. Banks has been removed. Edward Lofton,
Mr. Lofton is present, Judge approaching. Come on up, Mr. Lofton.
And Judge, just to clarify, I heard Your Honor say $2,500 on counts 3
what
and 4.
did I write on the thing? 2,500.
So
Okay.
5,000 total.
Yes.
So there's no misunderstanding. Thank you.
Edward Lofton.
Thank you.
Ma'am,
Mr. Lofton is before the court, a career offender, failure to register or provide info. And number 2 is a parole violation with a no bond hold.
Before you do that, let's just.
So I find probable cause on number 2, Mr. Lofton, you will have to appear before the parole board. And on number 1, I'll impose a $1,500 bond. All right, Brandon Ferguson.
Bonded, Judge.
All right, Mr. Ferguson bonded. I find probable cause. Bryce Hawes. Mr. Hawes also bonded. I find probable cause. Do we have Kimani Clark today?
I think he's,
No?
I think he's still on.
Okay. All right,
Is
Mr.
he
Clark.
still there?
And then do we have Tremaine, are we ready to address Tremaine Russell?
Yes, Judge. One brief second, Judge, I just want to inform my partner of one thing, Judge.
Okay.
Did I ever talk to you about what out-of-state holds means? Like what it means in the grand scheme of things? Let's say I get arrested.
All right, are we ready to address Mr. Russell?
Yes, Judge.
All right, Mr. Russell is before the court on one charge of possession of weapon or ammo by a convicted Florida felon. Number 2 is a violation of felony probation. And that has, it says interstate. Do we know where? It's interstate?
North Carolina.
Okay. All right, so it's a no bond hold for North Carolina. I find probable cause.
Judge, my client is asking me to make an argument today that I think is not in his best interest, and based on the fact that he has a no bond hold for a violation of probation, and that even if I win this argument, he's still going to have a no bond hold for a violation of probation. I'm going to exercise my judgment as an attorney and decline to make that argument today.
All right, so finding probable cause, we need to set a bond on charge number 1.
Your Honor, the state is going to be seeking a $15,000 bond. Now, I understand he has a no bond hold out of North Carolina. I don't know what's going to ultimately happen with that, but my concern is he's out on bond and GPS monitor at the time of this arrest for domestic violence battery by strangulation and domestic violence felony battery due to priors. He was just given pretrial and had his bond reduced. It would look like mid-September of this year. The state has filed a motion to revoke his bond on that case. It hasn't been scheduled yet. I would also note that the state has filed a notice to seek to have Mr. Russell qualified as a prison releasee reoffender. So I think the court should also take into consideration, if convicted of his other case, that he faces, one, that he would face potential enhanced penalties, and I'm not certain if this matter will qualify as well.
And Judge, one thing, I do understand what's currently before the court. As far as count 2, I attempted to advise Mr. Russell numerous times. There's really nothing that can be done at this time. However, I have to do what my client tells me to as far as in this respect, he wishes to address the court. I've advised him not to talk about the facts of the case, but he wishes to address the court at this time.
Okay?
Hey, ma'am. I made mistakes in my life. I got out. I bonded out to my way the whole month and a half I sworn to state. And I got out. That Monday I went to pretrial. Somebody Ubered me all my belongings from my apartment. Everything I ever owned. I went inside a pretrial with a big duffel bag with everything I own, like 500 comic books, shoes, clothes, and a big duffel bag. They put my stuff in the machine. They asked me, I said, just get out of jail yesterday. I'm coming to pretrial. I said, okay, they put it in the machine. And they said, they put it back, say, you have anything? I said, no, sir. That's just all my stuff. They put it back through, and they called somebody over. They said, do you have ammunition in your bag? I said, no, sir, I ain't been out of jail 24 hours. I said, somebody just sent me all my stuff. So they opened up the bag and said, can you just be please careful with my comic books, because that's the only thing I have left to even get myself together, because they're old and antique. They found 4 ammunition bullets. I told them I didn't know anything about it. I told them I didn't know anything about it. The man said, I believe you. He took them. He said, go to your pre-trial. Go to the pre-trial, get everything done. I've been home for 2 weeks. I found my first job ever in my life. I took my paperwork down there. They put me in jail for bullets. It didn't make my spirit like I just don't want to try no more, because I actually tried. I actually tried. I'm 40 years old. I actually tried mentally in my spirit to be a better person. It's not working. I'm not never lying to say they didn't take that out of my bag. I didn't put that stuff there. I just received my property. Getting out of jail because I was in jail. I lost everything behind.
Mr. Russell, I guess what, sometimes I know that based on how we're feeling at the moment, we just think that we have to, and your attorneys have been trying to get you not to say anything, because at this juncture of the matter, this is first appearance for probable cause finding, right? And so I do find probable cause. Any defense that you have, that's something that you're gonna have to discuss with your attorney for another day and time. It's not for today.
Can you at least arm me on him so when North Carolina gonna dismiss my probation? I know it's for a fact.
All right.
I just got a job. I just got myself situated. I bonded out. It took me another month and a half to even find a residence to stay. Now I'm back in jail. Like I bonded out in September. I didn't get out to November. That's how long it took me to find a place after I sold half of my stuff and what I owned just to get out. I sold almost everything I had just to place a bond. Then I had to wait another month and a half to find somewhere to stay.
All right, Mr. Russell, you have a no bond hold. There's nothing from North Carolina. There's nothing that I can do about that.
I understand.
And sir, I'm not going to ROR you because this is not your trial. I can't just take your word for it and say whatever. So that's not how it works. I am going to impose a $7,500 bond, and I'm going to order you not to possess any weapons or any firearms. And that's it for now. Okay? All right. And I believe that's it for our docket. Thank you, everyone, and I will see you all at 1 p.m. 1 p.m.